The Committee on Judiciary and Criminal and Civil Jurisprudence is now called to order. Mr. Secretary, call the roll.
Senators Schroer.
Here.
Gregory, 15. Brown, 26. Here. Coleman.
Here.
May. Roberts.
Here.
Schnelting.
Here.
All right, we have a quorum. I move that we now go into executive session. Do I have a second? Having a second by Senator Coleman. All those in favor signify by saying aye. Aye. All those opposed say nay. The ayes have it. We are now in executive session on Senate Bill 167. This is the bill from Senator Curtis Gregory heard last week, also known as the larger Gregory, as he stated. This one is on hazing, and if anybody has any discussion, I'll open it up. Seeing no discussion, I now renew my motion that we vote do pass Senate Bill 167. Mr. Secretary, call the roll. Oh, do I have a second? Having a second, Mr. Secretary, call the roll. Gregory. Yeah.
Senators Schroer.
Aye.
Gregory, 15. Brown, 26. Coleman. May. Roberts. Schnelting.
6-0, the motion passes. I now move that we get out of executive session. Do I have a second? All right, we have a second. We are now going to bring up Senate Bill 134 for hearing by Senator Fitzwater. All those that are going to testify today, make sure you fill out a witness form. And just quick by a show of hands, who's here to testify in favor of Senate Bill 134? And those against? Okay. And for the record, on Senate Bill 18, Senator May is ill, like many people in the building, so we're going to pass that bill to next week. So if you're here for Senate Bill 18, we will not hear that today. It's going to be next week. All right, Senator, please proceed.
Thank you, Mr. Chair, members of the committee. Travis Fitzwater, 10th Senate District, bringing Senate Bill 134 before you, so thanks for the time on this. This has three provisions or three parts to it that are important to me. Some of them have a little bit more work to do than others. The first is the sexual offenders within school properties, and this came about because a constituent of mine contacted our office about a very controversial individual that was approved either by a superintendent or school board in my district. It created a real ruckus, and this made a lot of sense to just ensure that they can't be even by approval of a superintendent or a school board. And when I called the superintendent to talk about this, because it became a really big issue, they actually appreciated some clarity in the law to kind of ensure that this can't happen in the future, because it's created such a problem for them. And so that superintendent in particular actually appreciated that there was some line drawn in the sand on whether these folks can be at school events, athletic events, things like that. And so that piece is really important for my district, and particularly one school area that has a real passion for that piece. The sexual offenders piece, where we're moving sexual offenders from different varying tiers, that one has a lot of work to do, and that one's one I think I've talked with several people. I think they're going to come up here and testify against the bill as it's written. I want to make sure there aren't a terrible amount of unintended consequences, because these provisions have been negotiated over years. There's been a lot going on. I'm going to commit to working with them to ensure that we get it to a spot where we are holding sexual offenders accountable. The reason why I have those provisions in the first place is because Lincoln County in particular has an influx of crimes against children that are really concerning, and so this should be on the top of our minds. How do we fix some of these things? And I think tougher crimes for some of these, or tougher penalties for some of these crimes, is really important, and so that's why those provisions are in there. And then the third piece that is really important. This is another constituent issue. There was a young girl who was raped several times by an adult, and the fact that they have to be pulled into court for depositions and hearings and all of these things, I think is just re-traumatizing these kids. So I just want to have the conversation about is there a way to do this virtually where the kids can be in a safer environment when they're testifying? And that's the intent behind that. Again, some unintended consequences with that I'm sure we'll talk about, but would love to work through these provisions and figure out if there's a way to provide solutions for my constituents as they bring these issues before us. So that's kind of the bill on a broad level. Hopefully there's some people here to testify in favor of it. I know there's some people here to testify against it for the reasons I think I just stated, but I'm glad to take any questions if you have them.
Senator, I want to thank you for tackling this issue. It's come up your Senate district abuts mine, and it's been brought to our attention that this is a necessity for the school districts, and it's a heavy issue. So I thank you for being calm and listening to all sides to make sure, like you stated, that there are no unintended consequences once we pass this. So you have my commitment to work with you on getting a product out of this committee that's going to meet the needs of our community, but also won't have the unintended consequences that you mentioned. Any questions for the sponsor? Seeing none. First witness in favor, please come forward. We're going to limit testimony to 5 minutes until we get closer to the end of this, since we don't have another bill to hear. So witness in favor, please come forward. Make sure you have your witness form filled out. Introduce yourself to the committee, and then proceed as necessary.
Good morning. Nice to see you all here this lovely morning with icy weather and, crap. So my name is Jessica Slows. I am here to talk in favor of this bill. I am one of the concerned parents that called Senator Fitzwater about this issue we're having down at South Callaway School District. I live in Hams Prairie. It's where I was born and raised. By birth, I'm an O'Neill. My family has been in Callaway County for a long time, since before the nuclear power plant, and a further 10 generations before that. Now, I'm not that old, or at least that's what I was told, but I feel like it. And I'm here to talk to you today about something that is inherently right or wrong. For most of us, this is what we would agree on. Some of you may know me from previous elections. I did run for my senator's House seat. I lost, but hey, that's okay. We're all winners and losers. My husband is a corrections lieutenant, and I'm a stay-at-home mom. So, excuse me, I have a little 1-year-old son at home. Senator Fitzwater actually answered phone calls and acted on the concerns and outrage of a group of moms from South Callaway School District. His bill, Senate Bill 134, addresses the issues that child sex offenders who have custody of a child are allowed to attend events on school grounds as long as the school board says it is okay. Now, that's not okay with us. Granted, I do have to razz the good senator a bit for attaching it to another issue that reads a little odd to me. And I assume that's what the people here to speak against the bill are going to address. As a mother, an aunt, and a woman in this community, I'll do just about anything to protect children from sexual predators. My son will be starting school sooner than I would like. I wish he could stay for a baby for a while longer, as most of you wish your children would have. When thinking about sending him to school, I want him to be safe and protected, to know that he is in good hands. At our school district over this past summer, it was brought up that a kindergarten or preschool teacher was contacting parents of former students offering to tutor them at her home during the summer months. She graciously offered to even pick them up from the local daycares and drop them back off. On the outside, this looked like a great idea, but then people found out about her husband. Am I allowed to say names?
Yeah, I think so.
Okay.
It's public knowledge.
It is. Jason Lallier, a convicted Tier 3 sex offender who also resides at their home. As people do, they started posting about this on social media pages, warning other parents of this danger. They started a whole discussion about how Jason has been spending time at the school for many children's events and even graduations, ball games, and helping with other things down at the school. South Callaway admitted that he was allowed on campus for school graduation, but nothing else. The school has refused to talk about this issue, and parents have come out with photos of Jason Lallier at school functions, not just the one that the school officials say he was allowed to be at. A few individuals with children at the school are afraid to come out at this point because of retribution for speaking out against allowing a child sex offender on school property. Nothing about this is okay. More recently, we had a local politician's son get arrested for having and creating child pornography. When most of these cases would get no bond, he was given bond and allowed to be let out to live with his parents, one of which his father is our commissioner, and his mother runs an in-home daycare. Nothing was said about the fact that he would be staying at a home with an in-home daycare. It wasn't until the group of us got together and started contacting prosecutors and judges saying, why is he being allowed to stay with his parents who run a daycare, that had been changed. We should not be afraid to stand up for our children. We should not be afraid to stand up against wrongdoing. There is nothing about child pornography and child sex that is okay. Senator Schroer, when you accepted the position as chair, there was an interview posted online, and you said to come to you with anything that would make our courts more fair and just. I feel this would be just and fair to keep child sex predators off school grounds. Senator Gregory, on your website, you talk about protecting women and children. Thank you for that. You also have a large section on transgender issues, saying you will aggressively pursue men that use women's restrooms. You would also like to stop men playing women's sports and keep schools from indoctrinating children with radical gender theory. Let's start by ensuring children are not being around child sex offenders at school first. I was going to talk to Senator Coleman, but she's not here. She has, I believe, 6 children. I know she would not want any of them to be around a child sex offender at this time. And like most of you sitting up there, you have children, you're an aunt or an uncle, well, the aunt isn't there, but you would not want child sex offenders to have access to your children. So it is important for this bill to stop child sex offenders from being in contact with our children.
Your 5 minutes just ran up. If you could just wrap up your testimony.
Okay. So on that, I could talk all day about this issue, but please, when you look at this bill, know that there are many of us behind you, and we will support you. Even if you only look at the first part of this bill, please take it upon yourselves to make sure this passes and our children are protected at school where they should be.
Thank you for your testimony, and thank you for running for elected office. I know it takes a lot of courage, a lot of commitment. Despite winning, losing, it's a lot. So thank you for taking time for that. Any questions for the witness? Seeing none. Next witness in support, please come forward. Make sure you fill out a witness form, and you have 5 minutes. I know you won't need 5 minutes.
I'll be much faster. Mr. Chairman, members of the committee, Matt Thompson here on behalf of Missouri Network Against Child Abuse to speak in favor of Senate Bill 134, specifically the hearsay provisions. Our organization believes that all minors should have the same support when taking the stand, not just those 14 and below. And with that, I'll take any questions.
Any questions for the witness? Seeing none. Next witness in support, please come forward. Any more witnesses in support of Senate Bill 134? Seeing none, we're going to move to witnesses against Senate Bill 134. First witness, please come forward, have a witness form, and proceed when ready.
Good morning. My name's Adam Woody. I'm a criminal defense attorney out of Springfield, former president of the Missouri Association of Criminal Defense Lawyers, and I'm here to speak on behalf of that organization. In my nearly 20 years as a criminal defense lawyer, I've had the opportunity to represent or speak with or counsel hundreds and hundreds of people who are on the sex offense registry. And I wish, kind of more people frankly had that opportunity, because I can assure this body that the vast majority of these people on this registry are simply people who, no doubt about it, made a terrible mistake at some point in their lives. But they're trying to pick up the pieces and put them back together and build a life for themselves. Try to be a productive citizen and try to have jobs, have families. They're hardworking, blue-collar people. But that's the vast majority of the people who are on this registry. And I understand that the general public's beliefs are vastly different than my own. I understand that. But my knowledge comes from experience and actual knowledge and dealing with these people and speaking with them and seeing them on a daily basis. Make no mistake, this is a marginalized group at this point. I mean, it's the modern-day scarlet letter. We all realize that at this point. And part of this body's job is not to continue to kind of step on the throat of our lowest rung in society. Part of this body's job is to provide opportunities for the lowest rung to work towards picking themselves up, towards trying to build something of themselves and be that productive member of society. These are people who have paid their debts, who have paid tremendous debts to society already. Most of them have served time in the Department of Corrections. All of them have completed MOSOP, the Missouri Sex Offense Program, which is the most rigorous therapy and treatment there is. They've all done that. So they now have the tools, and they're going to be out in society whether the public likes it or not. They're going to be there. So rather than continue to knock them down, they need to have opportunities to lift themselves up. Adding the provision where the Tier 3 offenders cannot go to schools, it's tremendously overbroad and unnecessary. So basically what that is trying to do is keep parents from attending their child's graduation, keep a father from going to their son's baseball game, keep a mother from going to their daughter's recital. You know as well as I do, I have children. That's harder on the kids than it is on the parents to look out and see an empty seat where their mother or father should be for something that they did 30 years ago. It's overbroad and it's unnecessary. I defy anyone in this room to point to one example of someone who's on the sex offense registry illegally touching a child when they're there at their son's or daughter's graduation or at a sporting event. It doesn't happen. It's an illusory problem that this bill is trying to fix. It doesn't happen. But what it does is it divides families. There's already strong mechanisms in place, as has been discussed. For example, if that gentleman is going to these schools outside of what he was granted permission for, rather than contact the senator, they need to contact law enforcement. That's a Class E felony. That's a failure to register as a sex offender. He could be charged with a separate Class E felony for going to the school outside of what he had permission to do. But there's strong mechanisms in place. The principal, the superintendent, the school boards, they know the families, they know the children. They're well equipped to deal with these issues and grant permission when it's warranted. There are certainly Tier 3 sex offenders who are no danger whatsoever. I would argue the vast majority are no danger whatsoever. They're just trying to live their life and have a family like all the rest of us are.
You get about 30 seconds left.
Okay, so 2 quick points. I would argue or ask this body to clean up what's already there as opposed to add new things to the bill. For example, back in 2018, the criminal code was completely modified, and in that is where the Tier 1, 2, and 3 sex offender lists were added. The intent at the time was to provide a mechanism for certain offenders to be removed from the list. It was a bipartisan effort with prosecutors, criminal defense lawyers, judges coming together and provide this mechanism for sex offenders to petition to be removed. For whatever reason, in 589-400, paragraph 1, subparagraph 7, The Supreme Court said despite all of that work and effort, it's still unfunctional, and for some reason they determined that because it says anyone who has been or is required to register as a sex offender is on the list for life. Despite the clear intent of the statute, the Supreme Court said there's no way to get off the registry. That's something that needs to be cleaned up because it was the clear intent in 2018 to provide the mechanisms for tiers 1 and 2 offenders to be removed.
Your time's up, but I do have a question. Can you clarify for those on the committee what the tier 3 offenses are?
Well, for example, there's even rape in the second degree is on there. There's more tier 3 offenses than any of the rest. There's more of those than there are tiers 1 and 2 combined. One thing is, for example, that it's rape in the second degree. It's a class D felony, and the wording of that is having intercourse with someone without their consent. That's an extremely broad thing, and I see people prosecuted for that all the time. For example, a husband having sex with their wife when she claims the next day that she was asleep and didn't consent to it. I've seen someone charged with that. That would be a tier 3 offender that wouldn't be able to go to their child's graduation. So things like that would be a tier 3 offense under a rape second degree. And there's a multitude of examples like that that I think makes this bill extremely overbroad.
Senator Gregory.
Yes, sir. Thanks for being here. I've never practiced in this area of law, so if I'm understanding right, tier 3 is the worst.
Correct.
So because I'm finding here's tier 2, statutory sodomy, child molestation. So it gets tier. So tier 3 then. Okay, here's tier 3. So tier 3, rape in the first degree. What's rape in the first degree is forcible rape?
Yeah, correct. That would be
Okay,
the
so that's included in this. Statutory rape in the first degree, which is what?
Sexual intercourse, I believe, with someone under the age of 12.
Under 12.
Correct.
Okay. Forcible, here's rape in the second degree. You explained that one. Endangering the welfare of a child in the first degree. What's that?
It could be a multitude of things as far as that goes. I mean, if it's, I assume that it says with sexual intent or something like that. Otherwise, it could be a multitude of things. Having drugs around a child would be included in that.
Okay. And so you're saying, I guess your belief is that some of these bad acts can't or won't occur at a public gathering like a graduation. You don't think it can happen there?
I'm not saying they cannot. And keep in mind, the school still has the option of keeping dangerous offenders out of schools. They can still do that. So I'm certainly not saying they can't. I can't think of one single example of ever hearing of it. And keep in mind as well, many of the offenses that you're talking about, those people are in prison. Okay, they go to prison for decades. It's not like they get a slap on the wrist and get probation and are trying to go to the school the next year. You know, they're in prison for decades. So the people who are out, who are tier 3 offenders, are the ones, for example, yes, rape second degree, things like that. So I'm not saying that it can't happen, certainly, but I'm saying the mechanisms are already in place to where it doesn't need to be additions to it. And it's just, the issue that I have as well is just the blanket, never. This category can never, no exceptions, period. That's an issue. There's always exceptions, and there should be.
Okay, thank you.
Any further questions? I have a brief question. I'm finding conflicting records right now on the recidivism rates for sex offenders. I see a study, I believe in 2014, that found 14.8% of men convicted of sexual offenses violently reoffend during a mean follow-up of 38 months. Another study said 20% after 10 years, 24% reoffend after 15 years. These are pretty old studies. Do you have any current information on the recidivism rates for sex offenders?
I'm sorry, Senator, I don't have those statistics in front of me.
Okay. Seeing no further questions, we're going to move to the next witness. Thank you for your testimony. Next witness against Senate Bill 134.
Good morning. First, I did want to thank Senator Fitzwater for listening to our concerns. I am Joanne Hagloff, and I live in Senator Gregory's district. I never thought I would be affected by the sex offender registry until a loved one made the bad decision to download materials that we all abhor. Like you, I want all children to be safe from sexual abuse. There are nearly 20,000 active registrants in Missouri, spread among the 3 tiers established by the Adam Walsh Act, which passed Congress unanimously and was signed by President Bush in 2006. 48 states have enacted legislation to give registrants a path to removal, either by post-conviction compliance or by petition to the sentencing court. Alabama and now Missouri are the only states that do not. In 2018, the Missouri legislature passed a bill sponsored by Representative Kurt Barr that provided the Walsh Act path for removal. But a divided Missouri Supreme Court in 2023 voided that part of the statute due to language that the judges found confusing, disregarding the legislative intent. As a result, all 3 tiers of offenders are stuck on the registry for life. Over the past 25 years, many studies have shown that the registry does not predict recidivism and does not actually serve the purpose of protecting the public. Long-term studies aggregated by Dr. Carl Hansen of Carleton University show that registrants who were convicted of a single sexual offense and who do not reoffend within 10 to 15 years have the same risk of committing a new sexual offense as any other adult male in society, and I do have some backing documentation for that. In fact, since 93% of sex crimes are committed within the family unit or relationship of trust, a child is at much greater for sexual abuse by someone in their circle than by a stranger on the registry. Yet, we have Missourians remaining on the registry for decades and lifetimes. The 20,000 registrants live all over Missouri. County sheriff's offices already devote tremendous resources to the cataloging and constant monitoring of those on the registry, many of whom have to appear in person every 90 days just to confirm that their information has remained the same. Those resources would have to be dramatically expanded if thousands of GPS monitors placed on people not committing crimes had to be overseen 24/7. This would take cops off the street or require counties to hire more personnel just to monitor law-abiding registrants. If this committee passes SB 134, we ask that you amend it to include what the 2018 legislature intended to accomplish, bringing Missouri in line with the rest of America. We ask that you not move most Tier 2 offenses to the already bloated Tier 3, a tier that was originally designed to include only the most severe offenses. And we ask that you remove the burdensome GPS for life provision. In conclusion, I am a mom, a grandmother, and like some of you, an attorney. I want all children to be safe, but I also believe that we want those who violate the law to pay their debt to society and demonstrate by their conduct that they will not reoffend, but will be productive and self-sufficient members of society. Lifetime registration is not keeping us safe and is costing us too much. Thank you, Senators, for your time and attention. And again, I would like to thank Senator Fitzwater for his willingness to listen and consider a compromise.
Thank you for your testimony. What was the 2018 bill? Was it 2018?
The 2018 bill implemented the tier system. I don't have the bill number,
Okay.
but it affected 589.400, 401, that entire thing. It established the 3 tiers based exactly on the 3 tiers set forth in the Adam Walsh Act, the federal law that mandates that all states have some kind of registry. And the Adam Walsh Act provided the path for removal based on each tier level. It provided tier 1, the lowest level, would be off the registry at 15 years, or could petition at 10 years for early removal. And again, by petition, I mean going to the sentencing court and showing that they had done all the things required of them, the sex offense therapy, not violating any provisions of the registry law, etc. Tier 2 would be able to be removed from the registry at 25 years, and Tier 3 could petition at 25 years. That was exactly like the federal law, passed unanimously by Congress. That was what Representative Barr wanted to have in Missouri, as are in most states, almost every state. And there was some confusing language left in the statute, which went through the trial court, the appellate court. The appellate court upheld the statute and said, yes, this is the intent was to have this removal system. But the Supreme Court looked at the language and said, it's too confusing, it doesn't say what it's meant to say, we got to look at the language. And they basically voided that part of the statute, regardless of the legislative intent. So what we're asking is that we reestablish that path for removal, because as the gentleman before me said, folks on this registry did commit a crime, did something that hurt a child or another person, and paid a heavy penalty for that. If you look at the amount of time that people are punished, they've paid their penalty. They've gone through counseling, they've gone through the therapy, they've done all the things, and they're trying to live a decent, productive, tax-paying life and get housing. Jobs and housing are, the obstacles to jobs and housing by being on the registry are tremendous, which I think you'll hear some other folks address. But that's what we would ask, that we restore that path for removal. We not bloat Tier 3, which is already the greatest number of individuals land on Tier 3, often because when they go to register, the registry officer just puts them in Tier 3 and often doesn't even follow the statute and put them in the correct tier. We have a lot of problems with that. They have no recourse except to hire a lawyer or hire a lawyer to talk with the sheriff and get that fixed.
Right,
so
thank you.
A lot of problems with the registry.
Any further questions? Seeing none. Thank you for your testimony. Okay. We have 40 minutes left. I know we have quite a few more witnesses, so we're going to move to 3-minute testimony.
Thank you.
So thank you. Please come forward. Make sure you have a witness form and proceed with your 3 minutes.
Good morning. I did practice this. It's about 3 minutes, 15 seconds. My name is Matthew Michaels. I'm grateful for the chance to speak to the committee. In October 2006, I was 21 and in college when I had sexual conversations with an undercover detective masquerading as a 13-year-old female and exposed myself via webcam. I wasn't thinking about my family, my friends, or my future wife and kids. I was stupid and selfish. I was arrested and charged in early 2007 with attempted sexual misconduct and attempted enticement of a child. I pleaded guilty and was given 120 days jail time and 5 years probation. I served 90 days and was released early for good behavior. I completed probation in June of 2013, again released early for good behavior. I have truly seen rock bottom. But today, I have now been married for almost 12 years to my beautiful, amazing, and most patient wife. We have 3 incredible children, 2 daughters, and my son being the youngest. My goal is to give my kids a better life than I had. My wife and I are raising 3 strong, confident young people. But because I remain on the registry, I have yet to be able to walk my kids into school for the first day. I have yet to sit in on a parent-teacher conference to hear how well my daughters are doing in school. I have yet to see any of their school plays or performances. I have yet to walk around with any of my kids for Halloween. It's a damn shame, and I have no one to blame but myself. I remember back in 2012 when I was applying for my first home loan, and I got my application back, and it showed my net worth was negative $40,000. I was buried in student debt, yet I was still approved. I like to believe somebody somewhere saw something in me and gave me a chance at being a first-time homebuyer. I remember in 2013, when I applied for a managerial position, I had no experience. During the interview, they asked me if I had ever managed people, and I said no, but give me a chance and I know I can do it. I was fortunate enough to get that shot, and today I'm lucky enough to be able to coach and inspire new and tenured employees looking to further their careers. I bring these two memories up because those on the registry face these two challenges every day: housing and employment. A chance to petition for removal increases the odds of achieving both of those dreams. Having a chance to petition for removal from the registry would truly be a once-in-a-lifetime second chance for myself, my family, my friends, my neighbors, my coworkers, and everyone I meet on down the road of life. It is not something I or anyone else in a similar position would ever take lightly. I strive every day to be a better person, husband, and father. My testimony today will not change the past, but I'm hoping and praying that it may change the future for myself and others. Thank you for listening.
Thank you for your testimony. Senator Coleman.
Remind me, if you would, please, because of the level of tier that you're on, will you be able to petition even ever to be removed, or is this a lifetime for you?
I am technically considered a tier 3.
Okay, so even your grandchildren, then, you won't be able to see their school sports either under the current law?
No, and I also have 6 nieces, 2 nephews. I can't go to anything.
But in 50 years, when you're a grandfather, the same rule will apply?
Correct.
Okay, thank you.
Further questions? Seeing none. Thank you for your testimony. Next witness, please come forward. You'll have 3 minutes. Make sure you put your witness form on the table.
Morning. Drove all the way down from Kirksville, Missouri today through some layers of ice. It's nice to be here alive. I'm here today to talk about the proposed laws 566149, which is the school exclusion.
Sir, if you could, for the record, identify yourself.
I'm Joshua James.
Thank you.
Thank you. Sorry about that. So I'm here today to talk about the school exclusion and also the modification to 589400 to 589425, which is the sex offense registration law. As someone who has lived under the existing statute for 566149 for the past 10 years, I can firsthand say that this law does not simply affect only registrants. It punishes their children, and I oppose it being expanded to other offenses or other offenders. Many registrant families are fighting to stay in compliance with the registration scheme. They are doing everything to keep up with increasing restrictions, compliance checks, the tiered registry requirements, all while being ostracized by their own communities and even their own government representatives. But this bill takes it one step further. It doesn't just make life harder for registrants, it actively creates a barrier between parents and their own children by inserting an unnecessary administrative approval or just a blanket restriction with the new proposal. And this limits normal parenting activities that every other parent takes for granted. Here are some examples of what the proposal and what the current law has in place. Simply dropping off your child at school. Dropping off your child at school is a Class A misdemeanor under the current law unless you have administrator approval. And what kind of offense is that? Well, if you did that without approval, that's a Class A misdemeanor. And the thing that seems strange about that is that there are sexual offenses that are misdemeanors. So we're equating that sex offense to dropping off your son or daughter at school? That doesn't seem right. And that's with the existing law. That doesn't even include this blanket restriction that they're trying to add just purely for Tier 3 offenders. But this also includes other activities like parent-teacher conferences. If there's a holiday performance, things like that. These are really common things that parents just take for granted and they go to. And I don't think that they should be removed or separated from their child in that way. And the big question with this bill, this is the 566149 bill, is what behavior are we trying to mitigate? And can this be narrowly tailored to address that without infringing parental rights?
Sir, just notify you your time is up, and I'll give you a couple seconds to summarize.
Okay. Yeah, so as is, this bill is overly broad. It's unnecessarily punitive, and most importantly, it punishes children by depriving them of parental support in their education. And I urge this committee to reject the expansion and consider the harm it will do, not just to registrants, but to the children who depend on them.
Thank you for your testimony. Any questions? Seeing none. Thank you for your time today. Make sure you leave your witness form, and if there's any additional comments, feel free to leave them as well. We'll distribute them among the committee.
I did type up a form I'd like to distribute to
Absolutely.
the committee.
Yeah, if you
That's okay.
leave it up there, we'll copy it and get it to everybody.
I already have copies.
Oh, perfect. Next witness against Senate Bill 134. Any other witnesses against 134? Please come forward.
Good morning, committee. My name is Eric Deal. Thank you for putting this together so we can discuss this very important issue. I'm here to testify in opposition to Senate Bill 134. I have a loved one affected by this legislation because of a federal conviction and is currently a Tier 1 for a non-contact offense. Those with federal convictions should be allowed to petition for removal from the registry after demonstrating rehabilitation and a clean record. This bill does not make it possible to remove that, to remove individuals from the registry. The registry and the related laws make it hard to find and keep employment, find housing, and reintegrate into their communities. Almost all sex crimes are by first-time offenders. Electronic monitoring for a lifetime will be expensive. This will be excessive punishment since those on probation already have to do routine polygraph tests twice a year and have a very low recidivism rate. It also adds to the even more mental stress, anxiety, and depression because it can be seen so visibly. Currently, there are 17,625 registrants in Missouri. 13% are Tier 1, 10% are Tier 2, 77% Tier 3. As a Christian, I believe persons forced to register who demonstrate positive change should be allowed a path off the registry and a second chance. Many who have completed their incarceration, their probation, their therapy are now law-abiding and productive members of society. I urge you to please vote against Senate Bill 134. Thank you very much for your time.
Thank you for your testimony. Any questions? Seeing none. Next witness in opposition, please come forward.
Good morning, everyone. My name is Clayton James, and I am a Tier 2 offender. I would have been eligible next year to get off the registry after 25 years. And I think some of what I'm going to talk about is the holes in the registry, let's say. Just they prevent things, but they just absolutely destroy some of the rehabilitation of the offender. I mean, how many of us are the people that we were 25 years ago? I know I'm not, and I know my friends are completely different people. They made mistakes in the past in their lives, and they regret them. But the registry, instead of really protecting our kids, which I completely believe in, I have 4 children of my own, and I would die for them. If somebody was hurting them, I would absolutely punish them to the full extent of the law. But it gives out information to anyone. Somewhere in Missouri, a guy can look me up, and if he's emotionally unstable or whatever, he can come over, vandalize or whatever. That I don't understand why John Yaya over in California needs to know where I live. Why somebody across Missouri needs to know where I live. Now I understand the concept of having this in like a community, like somebody's in the community, living next door or something like that. That I understand. But this other it's just one of the potholes of the registry. I just don't understand why that kind of information needs to be given to anybody outside that community that they're in. I also think that it is destructive to families. I have 4 children. I never have seen one of them graduate. I've never seen any school activities basically in 25 years. And that affected them. It affected them greatly. And it unfortunately affects a lot of families. Homelessness. Me and my family were homeless for 6 months because our lease was not renewed at our apartment, just because a newscast said there were offenders living in the area, and somebody was worried because there was a youth in need center by a 1.5 miles down the road.
Sir, your time has expired, but give you a couple seconds to wrap up.
The tier system gave somebody hope, gave somebody a target to, stay on the right path, and it doesn't make us free. It's not soft on crime. We're just asking that this, which is almost symbolic, to be given the chance to take part of ourselves back and to be able to live a full life and experience the lives of our kids as well. So,
thank you for your testimony. Any questions? Seeing none. Next witness in opposition, please come forward. And sir, make sure you fill out a witness form that's up there on the witness stand, and you'll have 3 minutes for your testimony.
Good morning. My name is Marcus Richardson. I reside in Columbia, Missouri, in the county of Boone. I sit before you today as a veteran, as a pastor, as a father, but I'm also on the registry as well, too. I've been on the registry since 2007. Back in 2004, I was convicted of second-degree statutory sodomy. I'm not here to say that I'm innocent or anything like that. I have served my time. I have did everything according to the law. Under the old system, which was the tier system that was available, it did give us hope that we were able to come off the registry and we're able to have somewhat of a life. Again, I've been doing this for the last 20 years. I'm an advocate in my community. I'm involved with my church. I'm involved with my children. I do different things in Columbia. I work with law officials. I've worked with probation and parole. I've worked with prosecuting attorneys. I mean, it's endless. If this goes into effect to where Tier 3s can't petition the courts to come off the registry, it would have a dire effect on my family because we have had the hope that after the 20 years, I would be able to come off the registry and do some of the things that I wouldn't say normal, but somewhat of a normal life. I understand law and order. I understand public safety. Again, as a veteran myself, I understand those aspects of those things, but also too, I do believe that there needs to be some type of, I wouldn't say incentive, but when we're talking about rehabilitation and when we're talking about being reacclimated back into society, I do believe that having the chance to be able to petition to come off there should be an option. I was sentenced to 4 years. My charge that I had when I went in was a Class C. Over the years, it got reclassified down to a Class D. And so even with that, I don't understand why the Tier 3s cannot petition the courts to come off. Again, it would be devastating to my family. It'd be devastating to my community, and it would force me to have to leave Missouri. I've been in Missouri for 40 of my 43 years, and I would be forced to leave from here if we go with this Senate bill that says that we have to wear monitors for the rest of our lives. And so that's basically all I have today.
Thank you for your testimony. Any questions for the witness? Seeing none. Next witness in support, please come forward. Or in opposition, I'm sorry. Any further witnesses in opposition?
Good morning. My name is Deborah Grund. I'm the president of an organization called Viewpoints. We provide a one-year transitional housing opportunity for men exclusively that are on the registry. Been in business since 2021. The tier system, while I understand that it needs to be in place, that people need to be held accountable, I'm dealing with men that have to take off a minimum of 5 personal days a year just to comply with the registry and taking only 1 polygraph test. It's difficult enough for them to find housing and then a job. Then you're turning around and asking them within the first year of their employment to take 5 personal days off. Do you know how difficult it is to get an employer to take that person? The organizations that I work with, the second chance employers, understand what these men and women are going through. They support my being here today. As a matter of fact, if we had a little more time, because we didn't know if this was going to happen today, I have CEOs that would come and like to talk to you about why their exceptional employees do not have an opportunity to petition, not guaranteed, but to petition the court to get off the registry. On a day that these men are forced to register, you have to understand 99% of them don't even own a vehicle. So this is a full day off from work just to get on buses to get them down to where they're going to register. In South City, where my housing, I have 3 houses, I do 21 men at a time. It is literally, bathrooms are bigger than this registry office, and they are required to wait until it is their turn. If they forget a document, they will come back. You are not allowed to take a document and send it through scan or mail. You have to come back. So they are under so much stress from their job and worrying about being compliant. The thing that's nice about my program is we work hand in hand with probation and parole. I'm on speed dial with the detectives at the registry. We do everything we can to make sure these men are towing the line. But even for them to get on a bus with all the apps that talk about sex offender near me, when somebody behind them, a phone pings, they don't know if the person behind them just got notified that there's a sex offender near me. These men live in a great deal of worry all the time. So I just am asking that we give these people who have done their time, who are in compliance, an opportunity, please, to let them lead a better, a less challenging life.
Thank you for your testimony. Any questions for the witness? Seeing none, make sure you leave your witness form there. Are there any other witnesses here in opposition?
Thank you.
Seeing none, any for informational purposes only? Seeing none, this will conclude the public hearing on Senate Bill 134. Having no further business before the committee, I now move that we adjourn. Do I have a second? All those in favor signify by saying aye. Aye. All those say no. We are adjourned.